Hello, this is Matt on the Moon Family Sedan channel. Attorney John Deaton, along with an attorney named William Gannon, have followed a request to file an amicus brief in the SEC v. LBRY case. So the way that this works is when you file a request to submit an amicus brief, typically what I've seen anyway, is that a copy of the actual amicus brief is included, and then the judge can either allow it or not allow it. If the judge allows it, then typically there has to be another submission of the exact same amicus brief anyway. But as a result, even though this is technically just an application, it's a request to be allowed to submit the amicus brief was included, so I'm going to share it with you. And this is fascinating. It's actually arguably more consequential than the decision that was already made in the SEC v. LBRY case. So you may recall that just over a month ago, LBRY did lose their lawsuit against the SEC, but the judge, in ruling in favor of the SEC, did not provide any sort of certainty, any sort of finality regarding secondary market sales of the LBC token, meaning if you and I were buying and selling LBC, the LBRY credit token, from one another, we wouldn't have any clarity today in terms of what that means. Is that somehow still some sort of unregistered securities transaction, which of course is an absurd idea, but that concept has been punted. And so we're at this stage now where even though LBRY has lost, it has not been determined what remedies will be required by the court. The judge could rule any number of things and could, and this would be wild, but could rule that even secondary market transactions constitute some sort of unregistered security transactions, even if LBRY goes out of business. And it looks like LBRY, it's going to cease to exist, the company LBRY. The LBRY credit, of course, is decentralized blockchain, so the cryptocurrency itself will continue to exist here. But at that point, it's just like, if it's an unregistered security, it's an unregistered security of who or what at that point. And so this is all addressed here, and it's very powerful. And I'm telling you, I'd be even more surprised if the judge, sides, or let me word it like this. I'd be even more surprised if the judge rules in favor, or comes to a ruling that would be more in favor of the SEC, especially if it includes ambiguity. Here, I'd be more surprised of that than I am the fact that LBRY itself lost this lawsuit. And it's just so fast. Like, this thing's 8 pages, and it is just pure gold. So maybe you'll hear I got some dead trees above my little Moon Family Sedan fingers right now, and I highlighted the parts that I found to be most interesting here. And we're going to talk about it. But it is powerful, including talk about what exactly would a common enterprise be. Especially since LBRY has cited, it looks like they're about to cease to exist. Like, what's the common enterprise? But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And I'll also say this is, on top of just being a fantastic piece, it is further proof that Attorney Deaton is fighting for the entire crypto industry. Yes, he's pro-XRP and he's an XRP holder, and I'm very pro-XRP, but I have 30 different cryptocurrencies out there. XRP is not my only interest, and it's probably not your only interest. There aren't exactly a lot of XRP maximalists out there, and I sure as hell am not one. I love XRP, my favorite crypto on the entire planet, my largest holding. But, I push back against maximalism of any kind, and so it's fantastic to see Attorney Deaton continuing the fight. And he's consistent in his message and the way that he's delivering it here. It's not just about XRP. It's about the SRC is dead wrong and harming the everyday investor. Also, shout out and credit to James K. Filan, attorney and member of the XRP community, for sharing this amicus brief. And let's go ahead and jump in. I guess actually I should first note that this was filed on behalf of Naomi Brockwell, who's on your screen right here, who is self-described a tech journalist, has a popular YouTube channel, among other things. And she holds the LBRY credit token, but she never bought it, and she's never sold it, which results in a very interesting situation when you consider secondary market sales. How can her position holding LBRY credit, which she never bought and has never sold, how can that pass the Howey test? Well, it's broken down in here. So let me just get down to page 1 of this thing, and the file is 30 pages, but that's just because there's, as is typically the case, there are exhibits attached. I mean, technically, the amicus brief itself is one of the exhibits, but anyway. So here we go. Interests of amicus curiae. Naomi Brockwell is well known to this court. She supplied a declaration dated April 28, 2022, which was offered in support of LBRY's motion for summary judgment. In fact, Brockwell's interests in this litigation were highlighted during oral argument. Through user tips, purchases by viewers, and user rewards, Brockwell has accumulated over 261,500 LBRY credits, LBC tokens. She has never cashed out any of her LBC because it is far more valuable for her to keep the LBC attached to her channel because staking helps her videos get viewed by a larger number of people. To this day, Brockwell has never purchased or sold a single LBC. Brockwell uses the LBRY blockchain every day. During the last 5 years, Brockwell accumulated LBC tokens through her channel, but was originally unaware that the tokens had monetary value. So let's pause. Does that sound kind of similar to what happened with the instance of a lot of XRP holders? So many, countless XRP holders the world over purchased XRP not knowing that Ripple exists. And by the way, that includes Jay, who created Spend the Bits, which is the best way to send Bitcoin around the planet. He didn't know that Ripple exists. He publicly stated that in his AMICUS brief that he filed in the SEC v. Ripple case. So this is a recurring theme. All sorts of tokens, because they're decentralized and not associated necessarily with one single company, you keep seeing the same problem over and over and over again, which should be telling any judge with half a brain that there's something bogus about the common enterprise arguments that are being made here. And you'll see, and we'll get into it too. This was one of the things I found most interesting in this. It's a little bit later in the video. But although the LBRY ceded that point, the common enterprise argument, which is a major mistake, we've talked about that before, Naomi Brockwell does not. Which, again, we'll get into it just a little bit, but I wanted to mention that as well. Anyway, the AMICUS brief continues. On November 7th, 2022, this court entered an order granting the SEC's motion for summary judgment. The court's order does not reference secondary market acquisitions of LBC, nor does it address LBC token holders like Brockwell, who acquired LBC for non-investment purposes. The court concluded, however, that many individuals, like Brockwell, acquired LBC for consumptive use only. And here's a quote from the judge. It's Judge Barbadoro in the SEC v. LBRY case. Quote, "I think this record does contain evidence that there are consumptive uses for LBC. I think that's undeniable," end quote. However, the court's order failed to, quote, "distinguish among the sales that were made to purchasers that had a bona fide consumptive intent and those who were offered and who purchased LBC tokens with a reasonable expectation of profit from the efforts of LBRY Inc., end quote." And that comes from the ineluctable modality of securities law. You may recall that's the gigantic document. I can't remember if it might have been like over 100 pages or so. It's gigantic. Going through all the case law to find that there is no interest instant in case law history, period, full stop, in which an underlying asset was found to be, by the nature of it existing, a security. It's just not the case. And so you need to distinguish between these things here. And so the judge, unfortunately, upon ruling in favor of the SEC, punted the argument of secondary sales. I just get the sense that he perhaps didn't know what the hell to do. And it's unfortunate because, like, you and I know, but we shouldn't assume just because a judge knows a lot more about the law than the typical person. I mean, maybe if you listening are a judge or happen to be an attorney, fine, you know a lot more than me or the typical person, fine. But for the rest of us out there, like, we know more than the everyday person if we've been paying attention. It's like I have, and if you're listening to this right now, you're probably just as interested in me and what's going on here. But we shouldn't take for granted that, that somehow means that the judge in this case understands exactly the same things we do, even though presumably the judge would be far more well-versed in pretty much every aspect of the law, period. But when it comes to this specifically, we shouldn't assume that the judge is aware of this, which is why it's so damn important that Attorney Deaton argue what he's arguing with Attorney Gannon, who put this thing together with him. It's absolutely crucial because, and this is at the heart of everything that's going. This is what's most important for XRP holders. Yeah, I mean, I like Ripple. I don't want them to be thrown under the bus. But you know, what's most important is that there's a path forward for XRP holders, meaning what happens on secondary markets. And that's what we're talking about here effectively with the LBRY credit. And now let me go down to, oh, right here. Yeah, bottom of page, what is that there? Hold on a second. I scrolled way far, actually. Hold on, I'm sorry, guys. I kind of lost my spot. I sincerely apologize. I thought I was on the correct page 1. I must have been on a different exhibit and thought I was on the right page as I started covering this. I sincerely apologize. But there's a lot of page 1s within this 30-page file. That's the problem. That's the real problem here. When I download these things, my God. One time early on, there's a document that must have been like 160 pages, and I hit print because I thought it was only like 20, but that didn't account for all the exhibits, and so I came back later, my little laserjet printer was like printing its little legs off. I was like, ooh, damn. I wasted about half a REMA paper, I guess a third of a REMA paper. Where is this? So I need to go 7. No, where is this? I am flabbergasted. Maybe it's because I was also just talking as I was scrolling through. I must have obviously just scrolled right past this damn thing. Oh, that's okay. So this is the application for the amicus brief. 1 second. I promise I will get us right back on track. 1 second. So that would be Exhibit A. Yeah, here we go. Here's Exhibit A. There we go. Okay. Oh, man. I haven't had this happen, and all the stuff I've covered, this is actually the worst. I've kind of bungled this, so I sincerely apologize, but I do the videos in one take. That's just how it is. I don't have time to go in and slice and dice and edit, so it is what it is. Here we go. Okay, so the argument, now this section right here. The token itself is never the security. There is no case law from the Supreme Court or any appellate court that analyzes whether an underlying asset of an investment contract is itself a security. The reason there is no precedent is because the underlying asset utilized in an investment contract transaction is never the security. And I was pausing it. When I first read that, I was like, yes, I want the judge to recognize this, which means that when it comes to secondary market sales, you must do what is right, which is to state that clearly secondary market transactions should be allowed. And I still do, despite all of this powerful messaging. I have a little bit of a fear, like the judge could still just choose to not address this out of wimpiness. I am still a little bit worried about that, but I don't know. With something like this, hopefully it'll give the judge the little boot on the rear side necessary to be like, oh yeah, I can reasonably come to a solid conclusion which does protect people participating in secondary markets. And then we got this section right here on page 3, which reads as follows. For example, claiming the LBRY credit token itself as a security would be akin to calling the oranges in Howie securities. Yes, exactly. And that's stuff that we've been saying in the SEC v. Ripple case forever. And I know it sounds obvious to us. I sure as hell hope the judge is recognizing this, though. It shouldn't be that difficult to come to the right conclusion regarding secondary market sales. It just shouldn't. And then there was this section right here. And this is actually from William Hinman. This is who's being cited here. Former director William Hinman. Yes, that William Hinman, the Ethereum Free Pass speech. They write, a former SEC director unequivocally stated, quote, the token or coin or whatever the digital information packet is called, all by itself is not a security, just as the orange groves in Howie were not, end quote. Now, look, as far as I think that William Hinman must be a very arrogant individual to just do what he did, and, you know, it just, I mean, if you think about this, all the stuff that he did, all the stuff that the ethics office told him not to do, the fact that he did that so flagrantly, what an arrogant individual who just doesn't care. He's like, Bill, I do whatever you want. And so, you know, I don't, you know, I don't agree with him on a whole lot of stuff, but on this, he is obviously correct. It's not the token itself. And it's important because this is somebody who is at the highest levels of the SEC itself, arguing exactly what Attorney Deaton is pointing out here with Attorney Gannon. And then there's this part. Here we go. Former SEC Chairman Clayton, see that's Jay Clayton, that little asshat, also agreed. And he said, quote, I agree that the analysis of whether a digital asset is offered or sold as a security is not static and does not strictly adhere to the instrument, end quote. So there you go. You got Bill Hinman and Jay Clayton saying the asset, and I'll just translate here, the asset itself is never the security. It's never the asset itself. It's the way things are packaged and sold. That's obviously true. And then the brief continues. These SEC statements make sense considering any asset or commodity can be offered as a security, whether the asset be orange groves, whiskey, chinchillas, condos, beavers, or Bitcoin. I'll just pause and note if that sounds like a strange mix of things to cite that are not securities. That's because all of these assets, yes, chinchillas and beavers, were core to multiple SEC lawsuits in the past, which is why they're cited right here. So it's never the underlying asset. I mean, is somebody actually going to argue to me that a damn chinchilla is a security by the nature of it existing? I swear to God, damn. That would be the most ridiculous damn thing you could argue. But anyway, amicus brief continues. When an asset is offered and sold as an investment contract, therefore a security, it does not transform the underlying asset itself into a security. Oranges remain oranges, and LBC remains LBC. Digital code. Amen, brother. And then there's this. Under Section 2 here. The Howey analysis applies to specific transactions at the time the transactions were made. The SEC has argued that what matters in this case is the economic reality of a transaction. Each transaction must be examined as of the time that transaction took place. Thus, each Howey factor must be satisfied for each transaction, and each transaction must be examined at the time that it was made. Any potential injunction issued by this court should expressly permit secondary market sales of LBC by persons unaffiliated with LBRY. And likewise, any potential injunctive relief should expressly permit the continued consumptive use of LBC. Damn straight it should. And then we jump down to here now, number 4. The LBC owned by Brockwell does not satisfy Howey. So again, this is Naomi Brockwell. This is the individual that this is all filed on behalf of. So again, the LBC owned by Naomi Brockwell does not satisfy Howey, which reads as follows, starting here. Considering that Brockwell acquired LBC through her channel and was unaware that the tokens had monetary value, the SEC must concede that the first prong of Howey could never be satisfied. Just pause to remind you, the first prong of Howey is an investment of money. So if you're going to try and say that Naomi Brockwell's LBC holdings satisfy the Howey test, meaning it's a security transaction, well, you have to prove that there's an investment of money. You cannot prove there's an investment of money when no money was invested and she was given the LBC on secondary markets. That prong is not satisfied clearly. Amicus brief continues. Furthermore, under these uncontested facts, it cannot be argued that Brockwell entered into a common enterprise with LBRY or any other LBC token holders. LBRY will soon cease to exist, making it factually impossible for a common enterprise to exist. LBRY may have conceded the common enterprise factor for purposes of summary judgment, but token holders like Brockwell have not. Additionally, considering that Brockwell was unaware of any monetary value associated with LBC, she could not have had a reasonable expectation of profits. Finally, any tipping or benefit that she did receive was solely due to her own efforts. The SEC is unable to satisfy even a single factor of the Howey test. And so, yeah, that's brilliant, right? I don't care if LBRY, I mean, I care. In this instance, I don't care, though. Like that, LBRY conceded the common enterprise argument. That's so regrettable. But from the perspective of Naomi Brockwell, and this is why it's pretty clear LBRY themselves should have contested this idea, because there are people, lots of people, who hold LBC who didn't know anything about the efforts of this alleged common enterprise. She just received the damn token, and now she's magically forced into a common enterprise? What the hell kind of nonsense garbage is that? So that's clear. And then this idea that there'd be expectations of profits. What are you talking about? Anything she got was from her own efforts, running her channel. That's it. LBRY themselves didn't do that. And these are just facts. These are actual facts that can't be disputed. That's why this is so damn powerful. And then looking at the conclusion here, reads as follows, and I love this. I'm going to cover two large chunks of the conclusion here, starting at the top. At the November 21st, 2022 status conference, this court expressed an intent to facilitate a resolution of the remaining issues in this case and a desire for the SEC to issue clarity regarding secondary sales. Specifically, this court expressed a desire for a resolution that would allow LBC holders like Brockwell to continue to use LBC on the LBRY blockchain without any confusion over whether those secondary sales are restricted. Despite this court's recommendation, coupled with the undeniable truth that many holders did not acquire LBC for investment, the SEC is unwilling or unable to provide clarity regarding secondary market transactions. The court ruled that LBRY offered and sold unregistered securities in the form of LBC tokens, but that does not mean that Brockwell and others are holding and using unregistered securities. Brockwell and thousands of others could be directly and negatively impacted if the court were to issue the extraordinary remedy of a permanent injunction without clarifying that the LBC token itself and secondary market transactions are still permitted and do not constitute securities. So let me just pause here. If the judge does not address this when it comes to the remedies portion of this litigation process, I will be disgusted, because the judge will just be punting this for his own satisfactions, that he doesn't have to deal with this, and it will be materially harming countless people the world over that use the LBC credit. It would be completely unacceptable. So the judge better do the right thing here and address this and make clear that anybody participating using in secondary markets the LBC token, that is not part of what was just ruled on in terms of it being an unregistered security. I get it. LBRY themselves lost. That organization lost. Fine. And I think that's BS. They lost. And probably not good to cede two of the prongs of the Howey test, which they did. That's regrettable. That had an impact. Let's not lie here. But my gosh, it couldn't be more obvious that secondary sales, like, that should be an easier conclusion to come to, frankly. That's just my personal, it's not a legal opinion because I don't have a legal background. So I'm just speaking as a regular, everyday person, but, without considering the legal implications, from, an actual, in the way that a legal mind actually would, that's, doing this career-wise. Just as an everyday person, if you come to bring somebody in this, catch them up to speed, like say they start as a blank slate and today just catch them up to speed on everything, I don't know how they could possibly come to the conclusion that the token itself or secondary market transactions would somehow be illegal securities transaction. It's an incoherent idea. That's the problem here. And so again, if the judge doesn't make that crystal clear in whatever ruling comes on down in terms of remedies here, I'll just be repulsed by that. And then let me jump down to this portion of the conclusion, starting here, which reads as follows. Despite this court's strong recommendation to provide clarity, the SEC either disagrees or prefers regulatory uncertainty regarding secondary market transactions. Therefore, any potential injunction issued by this court should expressly permit secondary market sales of LBC by persons unaffiliated with LBRY. Likewise, any potential injunctive relief should expressly allow the continued consumptive use of LBC. Fantastic. That's it. Oh, what a breath of fresh air. And I haven't seen every single document in the LBRY case to the same degree where, I literally saw every single legal document, so far as I know, in the Ripple v. SEC case, or SEC v. Ripple case, technically. But I will tell you, out of everything I've covered regarding the LBRY case, I've never seen anything worded like this, and I think that's because this is the first thing that Attorney Deaton has filed in this, and it's just so powerful. It cuts to the point, makes it very clear, simple to understand. But I haven't seen any sort of messaging like this in the LBRY case. I think it's much needed. So I'm very happy that Attorney Deaton jumped in with Attorney Gannon, and they both did a fantastic job so far as I'm concerned. Let me all know what you think, and I'll go ahead and wrap up here. And I apologize for bungling things a little bit earlier as I was scrolling through this, but it is what it is. I like to keep things raw, though. As far as the editing, I don't do the video intros like a bunch of people do, and maybe I will at some point in the future, I don't know, but I always just envisioned running this channel the exact way that I am right now when I started it just over 4 years ago, which is just speaking the same way I would if I were sitting down with you listening to this on a patio drinking a beer. Just talk like that. It doesn't need to be, somehow refined in any sort of way. I don't have to have perfect sentences. I just want to speak with like a normal damn human, you know, mistakes and imperfections and all. And so that's what it is. I'd rather just keep it raw. That's what I'm saying here. So I apologize for fumbling that a little bit, but I appreciate you sticking with me to the end here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.